On race courts, tribunals, emerging doctrines, and their impact. Just a couple of brief points before we get started. First of all, there's a paper for you to pick up at the registration desk. Second, please take some time today to fill in the evaluation forms you'll find included in the materials. They're really important to us in helping design future programs. And third, and most important, I'd like to take this opportunity to thank our very hardworking faculty who assembled this program. People put a lot of effort into it, and I hope you get a lot of benefit from the effort that did go into it. And I'd like to introduce our chairs for today. Toronto lawyer Grace Alison Permaul received an entrance scholarship to the Columbia University School of Law, where she received the degree of Juris Doctor. Her studies included advanced legal research on sexual harassment policies. She was a summer intern with the NAACP, a tutor with the Columbia Harlem Tutorial Program, and a member of the Columbia Human Rights Law Review. She was named a Charles Evans Hughes Human Rights Fellow by Columbia Law School. She currently represents employers and employees in all aspects of labor and employment law, human rights law, administrative law, and also practices in the area of Indigenous law. In addition, clients seek her advice and representation with respect to human resource matters, including equity and diversity, conducting workplace harassment investigations, anti-harassment policy design, and implementation in cross-border issues. She's the former chair of the Aboriginal Law Section CBAO, current chair of the Equal Opportunity Committee CBAO, a member of the main CLE committee, former editor of the Aboriginal Law Section newsletter of CBAO, and chair of the Joint Action Committee on Equity and Diversity. Michelle Williams obtained her Bachelor of Social Work degree at Dalhousie University and practiced social work before moving to Toronto to study law. She obtained her LLB at the University of Toronto, where she focused on human rights law and was an executive member of the Black Law Students Association of Canada. She joined the African Canadian Legal Clinic following her call to the bar, and she's a policy and research lawyer there. She identifies, researches, and helps to forward groundbreaking test cases before the Supreme Court of Canada, the Federal Court of Canada, and the Ontario Court of Appeal. One of her new areas of focus is to ensure that international human rights standards and procedures against racism are fully implemented at the local level. She's the key organizer of the First Canadian Preparatory Conference in preparation for the United Nations World Conference Against Racism. Please help me welcome Grace and Michelle.
Good morning. I'm very pleased to co-chair this event. I want to thank the panelists who've given their time today and everyone who's come to this inaugural CLE session on race courts and tribunals. Facilitating CLE sessions, continuing legal ed sessions such as this one, helps to ensure that the elimination of racism will be recognized as a legitimate legal and societal goal. I think the Law Society has taken important steps to reckon with racism and other forms of inequality in the legal profession through the creation of the Equity Initiatives Department as one initiative, and hopefully the support will continue for those sorts of endeavors. In my work with the African Canadian Legal Clinic, we daily translate critical race theory into practice and have helped to shape a new era of race jurisprudence through participation in such cases as RDS and Williams before the Supreme Court of Canada. We've come to better understand both the potential and the limitations of using the legal system to try to remedy racism and effect justice. And I just want to share with you a few realizations that we've come to in litigating race cases. First, there's generally a fierce resistance from many legal actors, including lawyers and decision makers at every level, to even hearing and considering issues of race and racism, which is sometimes in contrast to their position on other forms of discrimination. Second, there's a myth out there that racism does not exist in Canada, and this continues itself as a critical barrier to racial equality. That is, denial is often the norm when we try to raise race cases. And third, anti-racism and human rights protections are largely inaccessible, ineffective, and go virtually unenforced in a lot of cases. And this allows racism, including anti-black racism, to flourish. But the importance of critical race theory in addressing these realizations cannot be gainsaid. Critical race theory is an important tool, which Carol and other people will refer to, with which to address the problems of race in the law. In the broadest sense, critical race theory understands that law itself can be a vehicle for perpetuating racism and racial inequality. Consequently, this is an important day because the people who are on the front lines of ensuring racial equality in the law and the provision of legal services have come together for what I understand to be the first continuing legal ed forum on this issue. We have an amazing group of speakers who are doing the one thing I think that we all must do when faced with injustice. They're brave enough to actually raise race issues out there because it is the right thing to do, the just thing to do, and in doing so, I think they make a path for other lawyers to follow, and more importantly, they make a path for justice and equality. So I'm very pleased to be here to co-chair this event, and thank you all for coming today.
Just briefly to add to what Michelle had to say, I'm also quite pleased to be here. It's a privilege and an honor to be among people who have worked on the front lines and also who are creating the theories that are essential to practice, not only with respect to race issues, but that transcend into other areas of the law. I think it's critical for us to understand that the importance of the work that we do, regardless of the fact that it may be specialized in cases of race, translates into principles, legal principles and benefits in other areas of the law. And I think once that the profession begins to understand this, we will see more people undertake these cases and come forward to try and understand these issues and principles. I think what's also essential for us to understand is we are now at crossroads with respect to race issues. We now have a history, we have text that shows that historically, race not only exists, but has been litigated. With respect to that, James Walker's recent book, Race, Rights, and the Law in the Supreme Court of Canada, offers a historical account of what has happened over the years with respect to race issues in the courts, starting with Christie in 1940, Christie versus York, where blacks could not be served at York Tavern, and to the Narayan Singh case in 1954, discussing discriminatory immigration policies with respect to South Asians and others, up to reference to the 1948 P.R. Burton article, No Jews Need Apply, in which restrictive covenants and other discriminatory practices were widely exemplified, both in the law as well as in Canadian society with respect to Jews in Canada. I think that what we need to recognize and realize is that we're not talking about issues that are esoteric. We're talking about sound legal issues that emanate in the law as well as in our society. And what they have is far-reaching implications outside of law for all of us. Today you will hear our speakers tell you about practical approaches to bringing cases forward, how to mobilize the community, how to structure your arguments so that they have meaning, not simply in the context of your case, but precedent in other cases. No doubt you will see on our panels the leading experts with respect to these cases, and you will recognize that many of them have argued constitutional cases outside of race issues, which are also important with respect to the law, but also demonstrate not only their commitment, but their excellence and expertise in these areas. You will also hear about issues with respect to race in the workplace. You will hear about cases such as the Hines case in 1988, where although it was deemed that a black employee had been facing racial harassment, he had reported the discrimination to his superiors, nothing was done. No investigation was undertaken. And ultimately, this begs the question, are we actually a raceless society or a culture of indifference? For even though cases have come forward and individuals have brought to our attention the plight that they face, and race has been before the courts for a number of years, still no action has been taken to remedy these issues. Ultimately, we must ask ourselves these questions: where are we and where are we going, and how will we get there? But I think it's an imperative that we realize that it takes all of us to achieve the outcome that we're seeking to achieve in terms of remedying issues with respect to race. And I think that we are embarking on a dialogue that will engage us for many years to come and will require that we all come forward to the table with open minds in order to achieve our ultimate objective. Thank you.
It's my pleasure to introduce the first speaker today, Carol Aylward. She's a holder of a bachelor and master's in law and is assistant professor at Dalhousie Law School. She's been the director of the program for Indigenous Black and Micmacs at Dalhousie Law School since 1991 and is the first Indigenous Black Nova Scotian to obtain a Master's of Law degree from Dalhousie Law School. She's the mother of 2 and grandmother of 3 and an author as well. She recently published a book entitled Canadian Critical Race Theory, Racism and the Law. Carol's the past president of the Canadian Access to Legal Education Group, a former member of the Nova Scotia Police Commission, and a former member of the Nova Scotia Human Rights Commission. She received her call to the Ontario Bar in 1991 and articled and practiced in Ottawa. She received her call to the Nova Scotia Bar in 1995, and her teaching and research interests include criminal law, critical race theory, critical race litigation, and human rights. Carol currently teaches criminal justice, the individual and the state, and critical and legal theory, race, racism, and the law in Canada at Dalhousie Law School. She was born in Glace Bay, Cape Breton.
Thank you. Can you hear me? Oh, good. I teach critical race and legal theory actually not first years, I teach criminal law to first years, critical race and legal theory to second and third year law students, and I consider them to be a pretty tough audience. So I think this is probably going to be less difficult for me than it is to teach these 156 students. I'm going to start with a talk on the historical development of race and racism in Canada, and go through legal theory, starting with legal liberalism, which is the main analysis that we teach our students in law school, and on to critical race theory, and then look for a few moments at some of the cases that have been brought forward with critical race analysis, and also critical race theory in terms of how to actually put it into practice. I won't be spending a lot of time on the cases because other people are going to do that. And I hope your eyes don't glaze over when I go into legal theory. I practiced myself for a while, and I know that most often theorists are not speaking to practitioners. I'm hoping to speak to practitioners and sort of give some help in terms of how to put the theory into practice. I want to start by saying, first of all, that racial inequality is neither natural nor inherent in humanity. It is a social construct, and I'll talk a minute about what I mean by that. This CLE segment, and I'm very pleased to be here doing it, is basically, I hope, designed to deconstruct the myth or social construct of race, and to assist lawyers, those who are out there practicing in the trenches, to comprehend more clearly the more overt and covert ways in which law and race interact. Quite often, racialization is supported by law. We can look at what's happening in contemporary Canada and say this isn't so anymore. The fact of the matter is, though, that many of our laws, while neutral on their face, have an adverse impact on quite a huge segment of Canadian society. And in the past, we had laws that actually stated on their face that their whole purpose was to discriminate against certain groups in society. And for example, in Canada, the regulation of Aboriginal peoples by the Indian Act, the wartime internment of Japanese Canadians, the discrimination against the Chinese, against blacks and other people of color, are examples of law supporting what was an open racialized system. Other examples that we can look at from around the world would be the denial of civil rights to Black Americans in the former apartheid regime in South Africa. Notably, I think racialization operates even though the law seems to prohibit it. We can see that we have human rights legislation, for example, that prohibits discrimination, as does Section 15 of the Charter. And it still has powerful effects where it is only an implicit and unofficial feature of the legal and political system. Racialization is the result of a number of systems working together, and I want to talk about those for a moment. There are economic, cultural, and political systems. It is produced by the combination of social constructions of races as real and different and unequal in ways that matter, and the ways that matter are both economic, political, and legal. These norms, or what are considered norms, are now processed through a delivery system or a social structure, and individual actions within these systems perpetuate the racialization that happens in society. So what are we talking about when we're talking about racialization? Well, essentially, we're talking about selecting some human characteristics that are given meaning and are used as signs of racial difference, and sorting people into races on the basis of the variations in these characteristics. Then what we do as a society is that we attribute personality traits, behaviors, and social characteristics to these people or groups classified as members of particular races, and acting as if race indicates a socially significant difference among people. And through these sort of processes of selection, what happens is that we then attribute the idea that people can be judged by specific characteristics like skin color, texture of hair, everything but the size of ears, I understand, is not one of the characteristics that has been used, or the size of your feet. So if we didn't racialize people, we would not have the inequality that we have in society. But race is a myth. It's not supported by any scientific standard. We know that for a fact. Variations among human beings do not form regular patterns that allow objective classification. Whatever criteria are used to assign people to a racial category, such as skin color or hair texture, the evidence shows conclusively that similarities among many people placed in different racial groups are greater than among members of the same group. Supposed indications of race neither cause a person to behave in a predictable way, nor do they reveal anything about that person's character. So the very idea of race as a myth, because racial categories have no basis in fact, doesn't mean that race isn't important. It may be a social construct, but it has very significant and very powerful implications for human beings in society. I want to talk a minute about how race is constructed, and then go on and look at what happens in legal theory. Racialization essentially relies on classification, and like any other process of classification that is out there, it needs a sign of difference to sort people into these various categories. Notions of origin do this by setting the boundaries between different races and defining group membership. Signs of origin indicate who should be categorized into which racial group, and you can see over Canadian history, for example, categorization into racial groups has changed over time. At one point in Canadian history, Jews, for example, were not considered to be a racial group. When it became expedient to do this for economic, political, and other reasons, then the categorization changed. Today, you have less said about skin color than we have about origin. Origin is simply a category now designed to cover all of those other very specific categories, such as skin color, that were used in the past. They're not used anymore to divide people in the sort of specific sense, because it's not socially acceptable anymore to say we're going to use skin color to categorize, so we talk about origin. All racialized society use signs of origin to indicate racial difference. For example, the Negro school laws in Ontario and Nova Scotia created separate education systems. But these separate education systems were for black children. All other children, that is white children and non-black children, were not categorized into a distinct racial group. So from the perspective of the laws that segregated black children, these other non-black children were not seen as racialized, so that white children were not considered to be a specific racial group. Such uneven signs of origin are particularly common in societies such as Canada, where racialization is mainly implicit and unofficial. In other words, it's normalized. It's so normal, we accept it as just being there. We don't consider it anymore. At least those of us who are subject to the effects of racialization do see it, but others do not. In these societies, the cultural traditions of the group set the standards from which other racial categories are then distinguished. Members of the dominant group often do not think of themselves in racial terms. They apply racial labels only to people who are different, that is, different from the norm. Therefore, what happens is that many white Canadians do not ordinarily think of themselves as members of the white race, but they do identify black, Asian, South Asian, and Aboriginal Canadians as racially different from what is an unstated norm. In other words, whiteness is invisible, but the signs of origin of other races is not. So what difference does it make whether people are racialized or not? Well, it matters because racialization attaches meanings to perceived racial differences. These meanings stem from historical origins of racialization and the purposes for which it is used. The meanings of racial difference, like the signs of racial difference, may change over time, and they have changed over time in Canada, and in fact even from place to place, but the judgments and the assumptions that are made and tend to take the same form no matter what time or space in society we are. The importance of focusing on the span of history then is important when you're looking at how to implement critical race litigation strategies or looking at critical race theory. If we don't know what our racial history is, or the history of racialization in this country, we tend to develop the myth that has developed in Canada, which is that we are a non-racist society. If we don't keep track of how law has perpetuated historical disadvantages, we can't eradicate them. So, for example, if we don't know that Canada has a history of slavery, we're not able to look at why we now have, if you think of the word now being just simply inserted there to point out that in fact it has never not been there, but we now have a severe anti-black racism in this country. And we need to know why that is so. We have to know that we had over 200 years of slavery here, and that slavery had economic advantages for the dominant group. And in fact, when slavery was abolished, the backlash against these now freed slaves was of an economic nature. So we need to know how that got reinforced through law. Sometimes the meanings of racialization in Canadian society are often so subtle that even the victims of discrimination quite often cannot pinpoint or assert exactly the nature of the discrimination that they are experiencing. Now, one of the problems in Canada, as Henry Tater points out, is that there is an ideology or a democracy of racism in Canada. And that is to say that the majority of Canadians tend to dismiss very easily the accumulated body of evidence that documents racial prejudice and differential treatment. And they do this in spite of all of the experiential evidence that's put forward by victims of discrimination. Politicians and the power elite within mainstream institutions rationalize away the racial boundaries and the barriers that prevent people of color from fully participating in the major areas of social, political, and legal life. And they do this basically by putting forward the position that racism in Canada is an aberration. It is a result of an individual's personality or some extreme attitude that doesn't reflect Canadian society as a whole. And it is not Canadian society that is racist, but merely individuals. And if we deal with those individuals or those individual instances of racism, and we treat all people equally, then we will eradicate discrimination based on race. And of course, one of the problems with looking at discrimination as being simply an aberration rather than normalized in a society is that you can then put forward all kinds of arguments about why you don't need to deal with, either legally or socially or politically, the discrimination based on race in your society. One of the arguments that is quite often put forward in Canada is that racism cannot exist here in any great way other than in an individual sense, because we are a democratic society. And in a democratic society, we believe that all people should be treated equally, should have the same rights and benefits, and therefore racism isn't a problem. If it is a problem, it's just simply merely a problem with respect to just a few people. James Walker, as you heard about earlier, is an historian. He wrote a book which basically reveals the problem with the dichotomy in Canada with respect to the history of racism. And he looked at a number of Supreme Court of Canada cases over a period of time in which the court actually reinforced and upheld racism in society. And in fact, James Walker talks about the concept of Jim Crow in the United States, where people were not permitted to attend restaurants or theaters. It was very legalized segregation. And he talks about the fact that Canada had its own version of Jim Crow, and in fact, we also had legalized segregation in schools. Nova Scotia and Ontario particularly, schools were not desegregated legally in Nova Scotia until 1965. And in fact, when I went to school, I tell you my age now, but when I went to school, I actually desegregated the school that I went to, and the day that I started school in an all-white neighborhood, somebody burned a cross on our lawn, because we lived in an all-white neighborhood at that time. So as someone who's experienced the segregation in schools, I can tell you that it was there. Past president of the Barrister Society in Nova Scotia told me the other day that there was never any segregated schools, legally or otherwise, in the province of Nova Scotia. And I had a real problem with that, given the fact that I'd gone to one. So, but it does show you, I think, very clearly that there's two very different perceptions and experiences with respect to legalized segregation in Canada. The other argument that's put forward is that discrimination is something that we all face from time to time. A lot of us have heard that one. This implies that there is nothing distinctive or special about racial minority concerns in this regard. Another argument is that racism is a consequence of immigration. If we have racial conflicts, it is because there are too many different people here in Canada, as opposed to here in this room. And racism is a result of an increase in the numbers of immigrants who are peoples of color. If immigration is curbed, the argument goes, so also will be the incidence of racism. This, of course, ignores Canadian history, which has exhibited a pattern of racism and discrimination against many categories of persons, and the history of imperialism and colonialism with its history of slavery and the treatment of First Nations. So in other words, we had discrimination long before we ever had immigrants. The other argument that's put forward is that minority groups just refuse to fit in. All of these responses ignore the historical fact that racism exists against non-immigrant racial minority groups and continues today. For example, the Indigenous peoples, African Canadians, Chinese and Japanese Canadians. The other one is that racism is a problem for non-whites. This is a common myth, that the problem is that of people of color, that they have a chip on their shoulder, and they can solve the problem if they just put their minds to it. No, there's a notion that were it not for the people of color in our society, racism would not exist. Implicit in this view is that people of color are oversensitive, which makes them look for racism where it's not intended, and that it is racial minority group members who define the situation as racist when in reality it is not a factor. I talk about this in my book, which I have to plug because my publisher will kill me if I don't. This is what has been referred to as the race card. This is my book, by the way. I've done my job. This is referred to as the race card, and quite often, especially since I wrote this, a lot of people who say, well, what you're doing is you're asking lawyers to play the race card in court. Well, I always quote Johnny Cochran, who I invited to Halifax about 6 or 7 months ago, and he gave a talk to my students, and he said, race card? Well, gee, we never had the deck. We can't play it. The fact of the matter is, and when I talk about it in the book, I say that the idea that we are somehow using race in litigation when it's not legitimate to do so, I find, of course, very disturbing. But then I sort of think about it in terms of the gender card, and I have not heard anyone say, why are you playing the gender card? Why are you raising issues of gender in litigation? Now, it may have been true 20 years ago where you'd get this groan when you raised issue of gender, but I had never heard it called the gender card, and I guess I have to ask you to think about it in those terms, that whatever is a legitimate and relevant issue in the context of litigation is our duty as lawyers to bring forward, whether that is an issue of race, an issue of gender, an issue of sexual orientation, an issue of disability. we have a responsibility to our clients to do that, and to society, I would say. The other problem, or I should say argument that's put forward, is the one of formal equality. If we just treat people the same, it'll all work out. This, of course, ignores the historical disadvantages that certain groups have faced. I actually have produced a race card, which I didn't get finished before I came here today, which looks at formal equality and uses a playing card to do it. And hopefully I'll have it the next time I'm here, if I'm invited back. But this card actually has a visual depiction of what I consider to be this argument of formal equality. You have two runners on the track, and it's not the circular track that we've seen talked about in terms of disadvantages. It's a straight track. So we have a black man who is a runner, and we have a white man who is a runner. I didn't do gender, although I think I'll do one with gender as well. But in this, you have the white runner who is heading towards the goal, or the end, and at the end is opportunity. And that person is running on the straight track towards opportunity. There's no hurdles in the way, which I call white privilege, the fact that there are no hurdles there. And then you have the black runner who starts at the same place, but the very first thing that runner must do is jump over the hurdle of slavery. And there's a little space to land, hopefully, on his or her feet. And then there is the hurdle of Jim Crow. Slightly lower, the bar is slightly lower than slavery, but not much, and they have to jump over that. And so from Jim Crow, you get into segregation in education, segregation in employment. All of these barriers are in the way towards that opportunity, even though they're on the same track. And so I see it in terms of when you talk about just treating everyone the same. If we can't treat everyone the same because they're not the same. We have these barriers that the black runner has to deal with before they can ever get to the opportunity. So that means that what we need to do is to look at not treating everyone the same, but looking at substantive equality. What must we do affirmatively to give that black runner the same opportunity as the white runner has? And we do have to do something affirmatively. We just can't simply put them on the track with those barriers there and say they're going to get to the same goal at the same time. So formal equality is one of the problems. What am I like for time?
Running a little bit behind.
Oh, am I already? And I haven't even got to critical race theory. I'm going to move along now.
You keep going.
Okay.
Keep going.
Should I keep going? Yeah. Okay. After going through that, I want to talk about legal theory, which I know you're all going to fall asleep on, and I'll sort of bang my microphone to wake you up. And I'm going to talk about legal theory before critical race theory. Okay, what was there, and what is the starting point for our teaching of legal analysis in law school? So we start with the fact that Canada is a liberal democracy, and that there are liberal theories of justice. Okay, and when we talk about those, we say that law is a specific system of social regulation, so it's different than moral regulation. It is the chosen instrument of societies with respect to the regulation of persons within those societies, and it is entirely man-made. It is not, as some of our students think, from on high. We don't get these legal rules from on high. They are man-made. Therefore, I always point out, to my students at least, that the legal rules in any given society, including Canadian society, are the laws that represent the wishes of the dominant section in society, whatever that dominant section in society is. And under the traditional and standard method of legal analysis, the one that those of us who've gone to law school have learned, and that which is employed by most Western legal scholars, legal liberalism, it is argued that the general principles of law are neutral. Now, keep in mind what I said just before that it's man-made law and that it reflects the views and the wishes of the dominant society. So we go from there to looking at some of the basic tenets of legal liberalism. One of them is that law is neutral. And it's neutral with respect to what interests are going to be protected by the law itself. Well, those of us who are critical of law, particularly in critical race theory, say that that is just so much nonsense. Law is not neutral, that those views and wishes of the dominant group are not neutral. And so that law protects the powerful in society over the less powerful in society. The other tenet of legal liberalism is the rule of law, formalism, abstraction, and individual rights. Now, this concept of the rule of law, which is the basic underlying principle of legal liberalism, and it suggests that governments should be bound by known principles or laws without distinction in their application to particular individuals or groups. There is to be a single set of authoritative norms that apply equally to all citizens. In other words, a form of legal analysis that is separate and distinct from what is politically and morally right. And of course, the critics of this concept argue that this kind of legal reasoning is impossible in a setting of moral and political pluralism. And as a result, the division between law and politics disintegrates, and legal reasoning becomes equivalent to deciding which party in the case has the best moral or political argument. Then there is the doctrine of formalism, and this form of legal analysis is based upon the premise that legal rules do and can form a consistent and complete whole from which the answer to any legal question can be logically deduced. Now, this one is one that's quite often under attack by critics, and that's because there is no such thing as legal determinacy if you're anyone who thinks about law in a critical way. And that's because law contains too many contradictions. How many of us can take a legal rule or a case and argue it the way that we want to argue it in court for the best outcome for our client? So it cannot be determined simply because it has been decided a particular way in court. We can take that and we can manipulate it, and we do as lawyers. That's what we do. And the concept of neutrality, as I said already, just simply isn't there. The concept of abstraction, though, is the one that critical race theorists particularly have a problem with. And that is because abstraction means that you don't put the legal case into its social context. And we argued social context in RDS. It was accepted by the Supreme Court of Canada that social context is essential to determining rights in society. And because abstraction excludes a consideration of social context, we can't look at, in the ordinary course of legal theory, we can't look at what happens to a case when the victim is white and the perpetrator is black, for example. We don't look at race. Because if we looked at race, we would then be putting every case in a social context, and that would just be too confusing, the argument goes. We would have to do it all the time. And where do you draw the line? It's that old floodgate kind of argument. And they say that we have to have this sort of this sense of abstraction so that we won't be deciding moral or political or religious rights. But the critics demand that abstraction be replaced by contextualized law. And that is necessary because the legal liberalist insistence on abstraction obscures and falsifies and sanitizes human problems, while considering social context allows us to choose to tell the story by meeting head-on the social situation inherent in any given case. And that is where critical race theory comes in. Critical race theorists began to criticize legal liberalism in about the 1970s, started essentially in the United States, and actually, sort of grew into this international movement. And that is because critical race theorists said that legal liberalism failed to do an analysis of the role of race and racism in law and what part they have played in the political and legal structures of society. Critical race methodology requires a deconstruction of legal rules, and this is, as lawyers, what we need to be doing when we are introducing race into our legal strategy. We have to deconstruct legal rules and principles that challenge the so-called neutrality and objectivity of law. And deconstruction is designed to confront subtle forms of discrimination that is perpetuated by law. And there's very distinct steps in a critical race strategy. The first step is to be aware of the history of racism in society. If you're not aware of the history of racism, it's going to be pretty hard to be able to even know when race is an issue in a case. So you have to be aware of the history of racism, and you also have to know the role, the myth that Canadian society does not have a racist past plays in the perpetuation of racial oppression. So we have to know racial history, we have to know its role in law. We have to be able to contextualize from a critical race theory perspective, and the advocate or the lawyer and the judiciary must be aware of or inform him or herself of the experiences of people of color. Whenever I get to this point, my students say, oh, well, that means we can't do it because we're white, and we don't, how are we going to get this perspective or this experience of people of color? Well, my response to that is that you read my book, that you read books like the one by Constance Backhouse, which is really an excellent book on the history of racism in Canadian society, the role that race has played. My only problem with this book is that it ends in 1950 only because it would have taken her another 7 years to write it to bring us up to date, and I think she'll probably do that. But it is an excellent book. James Walker's book also on the role of race in the Supreme Court of Canada is another crucial one, and talk to your racial minority colleagues and get involved in those communities. Read racial minority papers. The second step in a critical race methodology comprises the ability to identify when race is an issue in a given circumstance, and the ability to identify those oppressions that can be overcome or limited through law. The next step is to deconstruct the discriminatory legal rule, and in my book I talk about jury selection, for example, challenges to the array, challenge for cause, those kinds of things, and also in other areas of law like family, contract law, civil procedure even. There are all areas of law that must be deconstructed, and what we do is we look at those legal rules or policies or doctrines or whatever they are, and we ask this question: does the doctrine, the legal rule, the principle, or whatever it is, subordinate people of color? In other words, does it have an adverse impact? And how do you know whether it has an adverse impact? Well, you ask your client, you ask that racial minority community, you do empirical studies, you look at expert evidence to determine whether it does or not. And if the answer to that question, does this law or rule have or subordinate people of color, if the answer to that is yes, then the next step involves an in-depth analysis of the rule to flush out what may often be hidden forms of discrimination. It's not going to come up and bite you on the cheek. You're going to have to look, do a real in-depth analysis to determine what those hidden forms of discrimination are. And the final step, and it's the one that I think is probably the most crucial, is reconstruction. Deconstruction in and of itself is fun, but it doesn't help us a whole lot. We need to look at what we need to do to replace that law or that doctrine with something that does not have a discriminatory impact. And that means that we need to think about alternatives, what the alternatives are. And I know I have a lot more to say, but I'm going to shut up now. I do have some handouts for you, though, that I did some diagrams that I hope might be helpful. Can I ask you to do? One is basically a diagram about, the kinds of things that we need to be looking at in terms of historical race and what's happening in contemporary society. I usually do this lecture in 2 hours for a whole year, and I'm sorry if it's gone kind of fast, but I hope you've got something out of it. Thank you very much.